Good afternoon to all attendees. Again, welcome to the third installment of the Financial Poise webinar series IP201, Legal Issues for Innovators and Inventors. Before I introduce our expert faculty panelists, I do have a few housekeeping announcements. First, I would like to thank our co-producer for today's webinar, the National Law Review. Please visit the National Law Review at their website. That's natlawreview.com. No spaces, all small letters, natlawreview.com. I'd especially like to thank the sponsor of today's webinar, Max Asset. Max Asset offers a simpler, easier, and better way to conduct single asset sales online, particularly in the bankruptcy context. Please visit their website for more details. As a reminder, the material in today's webinar is for informational purposes only. It should not be considered legal, financial, or professional advice. Please consult an attorney or other appropriate professional to determine what may be best for the needs of your specific situation. Again, I'm your moderator, Mark Bloom, and I'm based in Pittsburgh, Pennsylvania. Our expert panelists for today's webinar today are Gianna Julian Arnold. Gianna is counsel at the firm of Saul Ewing, based in the firm's Baltimore, Maryland office. Deanie Savasco. Deanie is of counsel at the firm of ND Gali Law, which is based in the firm's New York City office. We also have John O'Malley with us. John is a shareholder of the firm Volpe Koenig, based in the firm's Philadelphia, Pennsylvania office. And finally, we have Neil Peretz. Neil is the CEO of Innumero Law. It'll get it out right. And Neil is based in San Mateo, California. More detailed bios of our faculty panelists can be found at the end of today's accompanying slide deck, as well as on Financial Poise's website under the Faculty tab. That being said, we have a lot of important topics to cover today, so let's get started. I will begin with you, Gianna. What are some general ways to protect intellectual property types?
Sure. So our IP tools are patents, copyrights, trade secrets, trademarks, and contracts. Patents will protect your idea. Copyright protects an expression of an idea. You can use trade secrets for ideas or information, but it has to be something that you can keep secret. Trademarks are a little bit different. They're actually aimed at protecting the consumer, but trademark is a means to protect your product's good name or your company's good name. And then contracts are a tool that we use to preserve rights to all of those other tools. Each of these tools has requirements related to preservation of rights, related to ownerships, related to protection. So I'm just going to quickly give one example. Unless there's an agreement to the contrary, ownership goes to the inventor or the creator. So for example, if I were to hire Mark to design a logo for me, even if I pay him for it, if we don't have an agreement specifically signing the rights, then he's going to own the copyright of that logo.
Awesome. Thank you. Deanie, can you please tell us all a little bit more about patents?
Absolutely. So patents are a form of intellectual property that are issued by the United States Patent and Trademark Office, what we call the USPTO. It grants property rights to an inventor for a limited period of time. There are 3 different types of patents, and those are, I think, what most people think about when they think of patents. They think of utility patents. So utility patents are going to be granted for anyone who invents or discovers any new and useful process, machine, article of manufacture, or composition of matter, or any new and useful improvement of any of those. Utility patents are granted for a period of 20 years from the date of filing your application. And assuming that in order, once the patent issues from the USPTO, the PTO is no longer involved, and what you do with your patent is up to you, whether you enforce it or whether you even practice your invention. You are required to pay maintenance fees periodically in order to maintain the rights within those 20 years. Design patents are another type of patent. Design patents are granted to anyone who invents a new, original, and ornamental design for an article of manufacture. So, a few examples are probably everybody has a Scrub Daddy in their kitchen sitting next to their sink. Scrub Daddy, the ornamental design with the spiky hair, the face within the sponge. That is an article of manufacture which is protected by a design patent. Another one I think people are probably familiar with, if you've thought of the cell phone wars in the 2010s, where you have Apple versus Samsung. Apple had a number of design patents that it had filed prior to the release of the original iPhone. You have the design of the rectangular phone with the rounded corners. Those design patents featured very heavily in that litigation between the two companies. Design patents are granted for a period of 15 years from the date of issuance of those patents. And the third type of patent are plant patents. Plant patents are granted to anyone who invents or discovers and asexually reproduces a new variety of plant. If anybody is an apple enthusiast, if you've ever had a Honeycrisp apple, the Honeycrisp was created through crossbreeding, and that was actually protected through a patent that issued in 1991. So that's an example of what can be covered by a plant patent.
Thank you. John, question for you. Is it always best to protect an invention with a patent?
Yeah, we get that question a lot, and the answer is no. It's not always you don't always need to file for a patent application. In some cases, it doesn't make business or commercial sense. Generally, it makes good sense to file a patent where you're looking to kind of block competitors from using your technology, or you think you can license the invention to a third party. Sometimes it's worth just getting a patent if you're trying to raise capital, especially early on, if you're trying to get money from angel investors. Early stage investors often put a lot of value into patent filings, because it signals some kind of sophistication. And frankly, sometimes it just checks a box. They get more comfortable if they think there could be some kind of protection down the road to make the company more valuable. The other time it makes sense to patent is when the invention is really easy to copy. Typically, that's with some kind of mechanical device where it can be reverse engineered pretty easily, and your competitors can bring something to market pretty quickly. And then also, obviously, if you're going to invest the money in a patent, there has to be some kind of business value to it. There's cases where filing a patent doesn't make sense, or it's something to consider would be cost. Filing a patent can be an expensive proposition. Just that filing in the U.S. can be anywhere from maybe $7,000 to $15,000 with fees and attorney's fees. If you want to file internationally, it could be tens of thousands of dollars, so that's significant. Also, whether can you afford to even, if you get a patent, will you even attempt to enforce it? Do you have the money to do that? It also takes not a very long time, but it takes a long time. It feels like a long time to obtain a patent. It could be 2 to 3 years to obtain a patent. And if your product's going to be outdated by then it probably doesn't make sense necessarily to file a patent. Also, you have to keep into consideration when you file a patent, you have to disclose basically how it works. So therefore, your competitors, they can see how you do something. So in those cases, maybe just maintaining a trade secret would be better. And I know we're going to be talking about trades, or the presentation will go through trade secrets later. And then finally, I would just say sometimes the patent just won't be strong, or maybe it's not even patentable. A lot of software is patentable, but it's kind of very limited. It has to have some kind of technical association with it. So there's a lot of considerations, and it's something you should think carefully before entertaining.
Excellent. Neil, a question for you. Uh, we've just heard John describe some of the challenges with the patenting process, and what comes to mind for me is the amount of time that's involved. If I work for a company whose technology is very fast moving and I need to get to market quickly, knowing that my technology may be obsolesced, very, very fast as a part of the development process, I've perhaps I don't have time to wait on the patent system to catch up. In those circumstances, what are some reasonable alternatives to going down the patent path?
Yeah, I agree with all those considerations about whether to do a patent, and also consider that it is work to do a patent. And even if you have a patent attorney, you need the inventors working closely with the patent attorney to go document everything. So while they're doing it, they're not inventing something new potentially. They're working on diagrams and such. So I agree. I'm in Silicon Valley, and technology change is fairly rapid. So what I often recommend to clients as an alternative is to really think about treating it as a trade secret. And John already highlighted one advantage of that, which is it's faster. You go instantly can call it a trade secret, and there's not a special cost you're paying to the PTO. Additionally, trade secrets can last indefinitely, whereas a patent does have a finite life to it. You can have trade secrets for a long time. So that's usually what I recommend, if you can keep it secret. Now, if you want to have a trade secret, that you can't just walk around with a sticker and say trade secret, trade secret, trade secret, everything that's you want to deem as such and be protected. There are actually a lot of specific steps you have to take. And I think we're going to cover some of those on the subsequent slide.
Yes, thank you. It sounds like, particularly in those circumstances where the patent process may not be in sync perhaps with the pace of the technology development, a trade secret perhaps may be a viable alternative, along with other considerations such as first mover advantage, getting your product to the market quickly in this current hyper competitive environment. On the subject of trade secrets, Deanie, I would ask you to give us just a little bit more detail about exactly what a trade secret is from a legal perspective.
So, right. So from a legal perspective, a trade secret is really going to be any commercially valuable information that you have that you keep secret. It can be a formula, it can be a compilation, it can be a program, a device, method, technique. Really almost anything that you're using within your business that creates some sort of business advantage and value. One of the ways that I like to think about it is when you're thinking about your business is what are you doing and how and why are you doing it? I think, the most famous example, obviously, is the Coca-Cola formula. I think even if people aren't well versed in intellectual property, they understand Coca-Cola and the trade secret of that formula. And I think it's probably, as Neil was saying, trade secrets can last indefinitely. And I think that formula is probably one of the longest held trade secrets. It's been protected, I think, since the 1890s. It's obviously valuable to the company. There is a limited number of people that have access to it, that even know it at any given time. So it's really anything that you're using within your company that's giving you a competitive advantage that you're keeping reasonable measures to keep secret.
John, do trade secrets get any special protections under the law?
Yeah, there's no yes and no, I guess. There's no federal or state register to register your trade secret. But if you do, as was said earlier, as long as you do protect the information and remains secret and maintains its commercial value, then it is it is a right, and it is something that you can, through common law, state law, or federal law, you can, if someone steals your trade secret, employee or competitor, you can bring a cause of action in the appropriate court and receive, hopefully receive damages, and if it's worth it, if it's available, even an injunction. But with trade secrets, it's the key is it's the burden's on the trade secret owner to maintain the trade secret, and without that, then the trade secret is lost.
Neil, based upon what John just said, it sounds like it's trade secret law is really focused on state law. I'm just curious, does the federal government protect trade secrets?
Yeah, there is the Federal Defending Trade Secrets Act, just recently, it was within the last decade or so. It's the first time we've had a federal cause of action for protecting trade secrets. If you want to go avail yourself of protections under it, though, you do need to disclose in advance to the people involved, such as your employees, that your information is protected by that. So you can't retroactively apply the Defending Trade Secrets Act to people who might have already been working for you at that time. But otherwise, you're under state laws, and the state laws and the federal laws tend to go, mimic each other, I'd say, largely. So this slide here shows some of the elements that one needs to show, including that it's an actual secret and that it's valuable, actually. And we've had a bunch of recent cases where it turned out that one of the parties suing was not able to prove the independent value of what they were doing as compared to information that might be known in the market, or they were unable to describe carefully what exactly was secret amidst their trade secrets. You can't just say this pile of information somewhere and there's a trade secret.
And Neil, in that particular circumstance, how do you ensure, let's say that you're in some type of legal action, how do you protect the value in what otherwise would be a public forum of a court? I mean, what do you need to do to make sure nothing gets lost?
Yeah, well, in the context of actually litigating it, you would be filing your information under seal in court potentially, and you would seek a protective order in the court for information you're going to file. And then sometimes companies might sue each other in the hope of just gaining a trade secret as part of the discovery process. And in that case, you would often have litigation where it might be that only the attorneys involved on either side could see certain information as part of the discovery process, or just the court can look at it to prevent the transfer of trade secrets as part of fighting about it.
Mm-hmm. Gianna, a quick question for you. Can something be marked as a trade secret, designated as a trade secret, or does that give away the secret by doing that?
Yeah, so a couple of thoughts here. So first, never disclose a trade secret unless you have a non-disclosure agreement in place that includes continuing obligations for the life of the trade secret. Always read your non-disclosure agreements. A lot of them don't have that extra clause, and that means if the continuing obligations say 5 years after the end of the agreement, you've just now your trade secrets to the world after 5 years. You put a limit on it, so that's critical. I've seen some non-disclosure agreements that says the other party's free to use whatever they remember. So just because you get a non-disclosure agreement, it says non-disclosure agreement, doesn't mean that it's protecting you in the way that you need. Now, in these disclosure agreements, it's going to have language as far as how you identify what is confidential information and particularly what is trade secret. So to Mark's point, that's complicated, right? Because how much do you really want to put forward? One thing that I always counsel companies is, even if you have a non-disclosure agreement in place, you control what you say, right? And do you really want to go litigating some breach of a non-disclosure agreement when now your trade secret is out there to the world? So you disclose what you want to say and let the relationship proceed until you know that there's a certain amount of trust. Only don't kiss on the first date. Disclose the information you need for the business relationship to move to the next level. And another thing that I often caution on, and conferences are just a breeding ground for this, is again, you control what you do and do not say. And as a company, your goal is to obtain the clients. Your goal here is not to enable your competitors, right? So control what you say. So Mark, to your point, it's a little tough. I mean, sometimes that's the one nice clean thing about a patent in any kind of strategic alliance is it puts the boundaries upon around what you're bringing to the table. Sometimes what people do is maybe they'll prepare a disclosure like you would for provisional application with the idea that no other application is ever going to be filed, just so you have, and you're going to let it lapse. You don't want that to ever be shown. You're really doing it just as a way of encapsulating that trade secret so that you can say it's set forth in application XYZ and it's a provisional. But it is tough setting aside and bounding what indeed is the trade secret. The only last thing I'll say, and we're in the midst of this with one client right now, is a lot of entities, universities are a huge example. They don't want to be responsible for trade secrets, and it is against their mission. So, for example, in the present scenario I have, a client wants to do a project with the university, but we will be bringing trade secrets to the table, and they're saying that no, they don't want it. They don't want our trade secrets, but that's the only way for the project to go forward. So, what do you do there? Because there are oftentimes entities that don't want to be responsible for protecting your trade secret going forward.
Deanie, a question for you. I've read that one of the most difficult aspects of protecting a trade secret is the protecting it from the actions of your own employees. What can I do as a business owner to mitigate the risk of my employees revealing trade secrets? I'm not as concerned about competitors. Well, what about the people walking out the door every night?
That's a great question. When I'm as a litigator, I'm constantly thinking about risk, and I've litigated many trade secret misappropriation cases, so I've seen worst case scenarios. There's definitely things you can do within your own company to mitigate that risk. I would tend to put it into what I would consider three different buckets. So the first bucket would be some of the things that we've already touched on a little bit. You have your agreements. Do you have the proper agreements in place? So for employees, most employees are going to have employment agreements. You can have confidentiality provisions embedded within those agreements. You can have separate confidentiality agreements. But do you have the agreements in place that lay out for an employee what their obligations are and what you expect? NDAs play a little bit into that. If you have employees that are going to be speaking to third parties, you want to make sure that they know if they're going to be discussing sensitive information or if there needs to be an exchange of potentially trade secret information, that they have an NDA in place. And that also will prompt conversations between you and the employee, having those conversations of what they should, as Gianna was saying, what you should and should not say, even if you have a non-disclosure agreement in place. The second bucket, I would say, is training and education. There is a huge amount of information with surveys and polls going on. Deloitte did one last year, I think. Employees don't know what they don't know. Most employees are going to know patents. Most are going to know what a trademark is. Most are going to know copyrights. Trade secrets are a little bit of a different kind of animal. You need to educate your employees on, if you have trade secrets, what they are, what their obligations are to protect them, and how to protect them. So education and training, I think, is sometimes overlooked, but is absolutely key to mitigate any sort of risk of revealing those trade secrets. And then the third bucket, I would say, is do you have what I would call exiting protocols in place? So the instance where you have an employee that comes to you and says, I'm sorry, I'm no longer working for you. I've decided to take a job elsewhere. Do you have protocols in place before that employee leaves? Do they know what their obligations are? Do they know what contracts they signed at the beginning of their employment? Do they know, as Gianna mentioned, I think, do they know that they have ongoing obligations that continue beyond their employment with you? These are all things that it will help you reduce the risk of problems later if you address it up front, and things that you want to address before any employee actually leaves. I mean, that includes anything like if an employee has been using a laptop for several years, is it your laptop or is it their laptop? What do they have on that laptop? Are they allowed to take it with them? Are you going to make sure that that laptop is wiped before they leave? So there are absolutely things that you can put in place that are, and some of them are relatively easy and sometimes, generally overlooked, that can help you reduce the risk of something happening later on.
John, quickly, can you give me an example of a company culture that helps maintain trade secrets? What would that look like kind of in a practical sense?
Yeah, I mean, we keep coming back to Coca-Cola, but because it's a great example. So Coca-Cola is a company, and it really, I'll just reiterate what Danny said. It's there's three pillars of the agreements: training and exiting. Coca-Cola has been able to maintain its trade secret over the years, over 100 years, well over 100 years. And because they've done that, they've also limited access to trade secrets. Only a few people in the company have access to the trade secret. Other companies that are kind of similarly successful are the company that makes WD-40, the oil, that's still maintained as a trade secret over the years. And another example is Google. Their search algorithm is a trade secret, although search engine optimizers try to figure out what Google looks at, and they've had some success, but ultimately the algorithm remains a trade secret. On the other side of things, a company that the culture doesn't protect the trade secret, it doesn't maintain the trade secret as a trade secret. It allows probably too much access to documents, information. It's not retained on a kind of a need-to-know basis. And probably the best example of that I can think of off the top of my head is there's a famous case involving Waymo, which is the Google's automated self-driving division or subsidiary, and Uber. In that case, an employee left the company, and before he left, he downloaded roughly 14,000 documents, which were confidential files. And because Google did, in some ways, Google Waymo was eventually able to recover some damages for that, but there was a loss of trade secrets there. And it just shows you kind of the difference. Google, maybe different leadership in the different divisions, the algorithms is well protected, and for some reason they allowed an employee to download 14,000 documents. So even if it's 5 documents that the employee leaves with, that's going to be a significant issue.
Well, let's change gears a bit. Neil, can you explain the difference for us between copyrights and trademarks? Neil, are you still with us?
Neil, you're on mute.
I think you want slide 26.
Slide 26
is
okay. I will go back to slide 26. Okay.
Yeah. I think that's the question you're asking about, right?
Yes.
Yeah. So basically, think of trademark as being a source identifier. It's who is something from. It doesn't really matter who created the trademark itself. It could be AI, it could be whatever. The point is, a trademark is what you use to identify who is the originator and provider of something in particular. And it's important. It's actually, as mentioned earlier, it's a consumer protection law. Consumers want to know where things are from, and we shouldn't mislead them about where things are from. So under trademark law, we can prevent confusingly similar marks because they would confuse consumers about the origin of things. You wouldn't want a company that has a lot of high quality products to enable a cheap competitor who doesn't have the right quality to use its name because it would besmirch the bad name of the other company. It would mislead consumers. By contrast, copyright is intended to protect original works of authorship, like your literary work, your dramatic work. It could be even your photograph. And you wonder, with a photograph, what's happening there is the human is arranging the photo and setting it up and choosing when to go snap the picture, as well as maybe filters and other adjustments thereafter. So it's really protecting human expression, and the emphasis on human there is very important. If it is not done by a human, it won't get copyright protection. And there's a famous case involving a monkey who took selfies, and someone, I guess monkeys deserve lawyers too, so someone decided to represent the monkey and seek copyright protection on the monkey selfie, and that was not allowed. And more recently, we've had cases involving machine-created systems as well, not created by humans, so they're not the original work of authorship, if you will, of a human, and not worthy of that kind of protection. So I've got there's a brief example at the bottom of the slide here in terms of if you're describing a machine, you could describe your own description of the machine, as colorful as it may be, like the old J. Peterman catalog. You could copyright that, but you can't prevent others from writing their own description of the machine and getting a different copyright, for example, just like you couldn't prevent someone from drawing a painting of the same scene. They're not the subject matter of what is being written or drawn, etc. That's not subject to the copyright. It's only the author's work.
Well, let me ask the group this question. We currently are swimming in a sea of AI, and AI generated content and images and video and music. It seems to me that that would be ripe for copyright protection but from what you're saying, it's not. Perhaps someone could tell us, what's the current view of the Copyright Office as it relates to AI generated stuff. Anyone?
Yeah, well, there's certainly, I think my fellow panelists have additional, probably detailed thoughts on it. There have been several matters brought before the Copyright Office that were machine-generated works, if you will. And the position taken was kind of machines don't have any more rights than monkeys to get a copyright. So therefore, the machine, if it created it, isn't going to get a copyright. But there is also recognition that sometimes humans use machines to generate things. And in that case, there's a suggestion that you document what is the human aspect of the work, and maybe that could be subject to copyright, but you need to disclaim the inventions or artistic flourishes or the aspects of creation that were done by the non-human.
Mm-hmm.
Yeah, I would just throw out too that AI is having implications as well in, when you're looking at libraries and models, as far as on the patent side, what's considered obviousness and what's not. And then in the business realm, I do a lot in the life science space. And if you start talking about life science tech, we're now seeing AI exhibits in our broad strategic license agreements because people need to have faith in what's feeding into the underlying models, right? So those two areas that I'm seeing change.
Yeah, I think building on that, there's an issue of it's not completely determined. What if I use someone else's copyrighted material to train my model? And there's debates about what does that mean for implications for the model output that it was trained on that. If you essentially building on someone's copyrighted work in a way, and there's a recent preliminary report by the Copyright Office that maybe my fellow panelists have studied more recently than I have. It just came out shortly before they then fired the head of the Copyright Office.
Gianna, just to stick with you for a moment, I've heard about the importance of registering my copyright. Can you tell us a little bit about what that means and what it does for you if you register your copyright?
Sure. So unlike patents, there are not strict time requirements as far as copyright, but there's definitely benefits to registration. It creates a public record. So that's providing notice of the copyright claim to others, whether or not they see your work. It allows you to file a lawsuit to enforce the copyright in the federal court. If you file it within 5 years of publishing the work, it's evidence that your copyright is valid. If you file within 3 months, it enables you to claim statutory damages and attorney fees, and that can be quite useful. As mentioned, there's not strict timing requirements here. So if your item is changing often, or if you have many, many items, you might not want to register every item straight away. And in that case, your process might be you file an item when you see it becoming very valuable, or you see that somebody else is infringing it. And then at that point, you file when indicated, and you can then provide someone a cease or desist letter, but you would only get damages, from that point forward. And then definitely, no matter what your policy is, make sure you're doing your copyright markings on your works.
It sounds like registration is a lot easier than, say, filing a patent. Is that true?
Yeah, absolutely. Registration of a copyright, and oftentimes what we'll do is we might help a company run through their first couple of registrations, so they have a process in place. So rather than always having to go through counsel for every single registration, you get somebody that knows what needs to be included and run the company through the process, so it can become something you can do internally, lower the burden a little bit.
Good, thank you. I think that just to highlight a little bit more about trademarks, I wanted to ask Deanie about registering trademarks. We just talked about registering copyrights, but what about registering trademarks?
So registering trademarks is similar to copyrights in that the registration in and of itself is going to confer a specific set of benefits to you as a registrant. The two that really stick out to me are when you register a register a trademark, you're going to get nationwide protection. An unregistered mark, you're only going to get local protection where you're using it for your business. The other benefit to registering that sort of, again, from a litigation perspective, is you get the full breadth of remedies available to you for a trademark infringement case. You can file a case with an unregistered mark, but again, your area of infringement is going to be much smaller and your remedies are going to be much less. So in terms of should you or should you not, I think if you're going to have a trademark and you're going to invest in your branding and your business, and that trademark is important to you, and you want to input your resources into development of that mark, it really makes sense to register it so you can get the full protection of the law to the extent allowed.
Thank you. Let's move away for a second from formal protections for intellectual property. We've talked about filing patent applications, registering copyrights, registering trademarks. Can we protect our intellectual property with contracts? And what are some examples? And Neil, I'll start with you.
Yeah, we've got a few examples on the slide here. And I consider contracts to be formal as well. I just have to take the extra step of getting the court involved to go enforce them. But certainly a lot of, I'd say maybe everyone dialed into this is probably familiar with the concept of a non-disclosure agreement, which would be the first way. If you're going to share some confidential information, including a trade secret, you would put a non-disclosure agreement in place. And there's a lot of subcomponents of the non-disclosure agreement that you have to be careful about. Are there exceptions, for example? And one of the ones highlighted earlier by a fellow panelist is there an exception for things that they learn from it or memorize. And, so you need to be careful about that. People sometimes call that residual clause. So it's important to scrutinize your non-disclosure agreement. There was another earlier observation that was very important, which was you still control what you say. So there's the agreement that's put in place, and then there's a question of what do you really disclose? So you can put the non-disclosure agreement in place, but still you might want to be careful what you disclose to someone because you might not know behind the scenes what they're doing, maybe even in contravention to your non-disclosure agreement. So you should be mindful of who you're sharing information with. You certainly can have a license agreement in place if you're allowing someone to use your intellectual property and limit what they can use it for, under what circumstances, maybe only in a certain field of use, maybe only in certain geographic areas. And then there's the concept of harvesting your own intellectual property. So a key agreement you'd want to put in place is an intellectual property assignment agreement. And that's to go protect a situation where you have someone working for you. It could be an employee, could be a contractor, either as an individual contractor or an entity. And they're creating intellectual property as part of their work. You want to make sure that you own that. And the way that you do that is through this intellectual property assignment agreement. And oftentimes you would provide this to employees right when they're getting signed up as an employee at your company to make sure that you own all the work. In the case of a contractor, you might specify, hey, what you're doing is work for hire, but you'd want to have kind of a saving clause because work for hire is a special term of art. And if it turns out that for some reason their work is not deemed to be work for hire, you'd still want to own all the intellectual property.
Excellent. Just to switch gears a little bit with our discussion, obviously some of the items that we've talked about today, filing a patent application, trademark registrations, copyright registrations, it's important to follow all of the necessary steps and precepts in doing it. Oftentimes, the question will be asked, do I really need an attorney to do all of these things? And if the answer is yes, then what are some of the questions that you should ask a potential attorney who could be representing you in the future in order to vet them to ensure that they're right for your circumstances? And I'll ask Deanie this question. Start us off on, we'll call it interviewing a potential counsel for your business.
Sure. So, well, to answer the first question, do you need an attorney to file an application for a trademark or patent or a copyright registration? The answer is no. You don't have to be an attorney to file any of those. You don't have to be an attorney to go onto the USPTO website, the copyright website, and register your IP or to prosecute your patent. Is it really a good idea? That's another question. If you're going to interview an attorney, the kind of questions you want to ask. So, for example, if you have an invention, you want to, and you decide that you want to file a patent, there are attorneys that only prosecute patents. If you're going to be a patent prosecuting attorney, there is a separate bar you have to take. We call it the patent bar. There's a whole host of requirements that you need in order to even sit for that bar. So if you're going to file a patent, for example, you want to ask the attorney if they are familiar with the technical aspects of your invention, because you will have attorneys that are by trade electrical engineers, mechanical engineers, software engineers. If you have an article of manufacture that is, some type of computer program, something like that, you want to make sure that the attorney that you're interviewing has expertise in that technical area. Some prosecuting attorneys will have a more general area of background, and others will be more specific because there are, for example, if it's a biotech patent, I myself am a molecular biologist by training. I don't prosecute patents, but that is my technical background. So you want to make sure that the attorney that you're working with has the proper technical background, especially if you have a particularly technical invention that you want to patent. For copyright and trademark registrations, I think you just want to know the experience the attorney has, how often they register copyrights, what their experience has been, how long they've been doing it, and the same would be for trademarks. For trademarks, it would be, how long they've been doing it, what types of industries if they tend to focus on particular industries, things like that.
Mhm. And I would imagine that if you are seeking investment in your company, those potential investors would want to ensure that your intellectual property is very well protected, and they might look askance if you were doing everything yourself. They probably would feel more comfortable if you had experts doing it. Is that a fair statement?
I would agree with that, yes.
Excellent. Uh, just to spend the last 15 minutes of our call today, I just wanted to kind of paint the picture of a hypothetical. And the hypothetical is I have a friend. Uh, it's not hypothetical that I have friends, but hypothetically, I have a friend, Anna, who is the CEO of a company called Draw AI. And Draw AI is an international business that releases cutting edge tech all the time. It was established business in the digital design field and currently has quite a devoted following. What kinds of intellectual property and other legal issues might Anna's business face on a regular basis, given everything that we've previously discussed? I'll start with Gianna. What do you think
Yeah.
about?
Well, so Anna's likely going to use every IP tool there is. She's going to protect her branding with trademark, her design expressions with copyright or design patents or trade dress. She might have specific tech innovations that are suitable for patent. She might have IT tools and business know-how that are trade secrets. She's going to be using a broad range of contracts, and the ownership provisions are going to be really important. But we also have to look at the other side of this. We've been focusing on protections to keep others out of a space. Anna also needs to consider whether she's even free to do what she wants to do. In the copyright space, for example, there are robots out there on the web just looking for somebody that's using somebody else's image or what have you. Trademark people monitor those carefully. If you use somebody else's mark, somebody else's slogan, it's amazing the types of sayings particularly that have been protected. She doesn't want to be using one of those sayings in her marketing materials and then all of a sudden be infringing somebody else. Last thing she wants to focus on her company. She doesn't want to focus on stepping into trouble with somebody else. So on the one side, she can use all these IP tools to protect what she's creating and what she's doing. But on the other side, she needs to keep a good eye open to make sure she's not getting into somebody else's area of protection.
Mhm. Uh, Another question that I wanted to ask regarding this particular scenario, let's assume for a moment that this company, Draw AI, is growing substantially, and their outside counsel bills, they've decided to use outside counsel for a lot of this work, has now surpassed what they potentially would pay an inside counsel to do. So, what are some of the considerations for Anna to think about in order to bring some of this work inside? What can an in-house counsel do for Anna and her company? And I'll ask Deanie that. What do you think?
I think the first thing that comes to mind is when you have your own dedicated in-house counsel, your in-house counsel now has one client. Your client is you, it's only you. They're focused on your business, your needs, your IP. Outside counsel, obviously, we work with many different clients at the same time. If your IP is that, if your company is that IP focused and you have that much IP work, it may make sense instead of using outside counsel for all of your needs to bring a bulk of that in. You can find somebody by hiring somebody to work in-house. You can look for somebody with a particular expertise that you're looking for, with a particular background that has potentially previous experience in your industry. So there's a lot of different considerations. But it's definitely something, if you are regularly using IP counsel, need IP counsel, you have ongoing IP concerns. If your company, there's some companies, unfortunately, that are just big targets for litigation. If you are a repeated target of litigation, you may want to bring some of that in-house. You're not going to be able to get rid of all of it. You're still going to need outside counsel, again, if it goes towards litigation or something like that. But it is definitely a consideration for a lot of companies, whether they want to bring a lot of that work in-house. And a lot of it will have to do with budget. If you have the budget to bring on someone who's salaried that you pay on a yearly basis, and that makes sense to you financially, then it might be something you might want to consider.
Hmm. Neil, a question for you. Uh, let's say Draw AI is very, very innovative, and their employees create lots of types of intellectual property, but they're not all focused on the core business of Draw AI. So their thought is to monetize some of this, I'll call it extra IP or non-core IP. Let's talk about licensing intellectual property, particularly out licensing. Tell us a little bit about how a license could be utilized to bring value back to a company like Draw AI.
Yeah, if they have something that is time saving, money saving for a third party that they've developed, and they feel like they've got sufficient protection on it, or the protection could be trade secret protection, and it's advanced in the market, they could go out and potentially license it out to third parties. They're going to need to go through that same level of being careful, even in the licensing negotiations, though, because they don't want to reveal things that the other side might say, oh, I can kind of go build that myself. And potentially they need to go set up an agreement that really documents what they have, and the other side to agree, no, we're not even close to that. So you can keep track of whether the other side went and decided to just learn from you and go build it themselves. And then the last thing, you really need to figure out auditing and how are you going to keep track of how much of it they used. So you're going to get into some very interesting pricing questions there. Are you licensing the technology on a one-time basis, on a per-use basis? And then how are you going to keep track of where it's used? And then in some cases, folks want an exclusive license. It could be for a certain geography or certain use case. So you've got to figure out, how do I keep all my rights holders in their swim lane, if you will, without then creating trouble with my other licensees for something. So I think they're going to require work to go license this out. It's going to be legal work. It's going to be business development work. So they need to make sure they're going to generate enough money from this activity to even warrant running around and shopping it.
Mm-hmm. A question for John. John, if this technology has had a patent application filed on it, and it turns out to be fairly agnostic as to its application, it's not as valuable to the company because they have a different focus. But what they've learned is that there could be more than one industry that's interested in applying this particular technology that's had a patent application filed. How do they maximize the value of their intellectual property, knowing that I don't really want to file, I don't want to negotiate an exclusive license, but I want to license it very broadly? How would I do that to maximize the value?
So, you can negotiate terms into the license agreement, and you could include basically a field of use license, it's called. And that's just a term in the agreement that lets you limits how the licensee can use your intellectual property. It can be done by industry, it can be done by region, EU, UK, South America. It can be product type, or it can be how the invention is applied. So for example, it could be some open source software. Even some software is permitted to be used for private use, but if you use it for commercial purposes, then you have to pay a license. or similarly with software, you could have license for education again, but not for commercial enterprises. So it's really a good way. The field of use is a good way to kind of maximize the value, but it can also, if it's used strategically, it can help you kind of grow your business in areas where you didn't think you were interested in. You can see how other people are using it and developing, and maybe that's something you would like to move your business into after you see the success.
Excellent. Thank you. In the last few minutes that we have today, I wanted to focus on the subject of litigation, not from the nuts and bolts of litigation, but from a holistic viewpoint of litigation. My feeling is that litigation is very expensive and time consuming. And if I have a small business, perhaps it's not something that I would have the resources to engage in unless I'm absolutely forced to do so. What are some alternatives that are available to litigation? And I'll start with Deanie, and I'll also ask Neil and Gianna to finish us up in the last 5 minutes here on this topic. So, Deanie, starting with you.
Sure. So you're definitely correct, Mark. Litigation and particularly IP litigation tends to be quite expensive. Um, Most companies, you want to try to avoid it if possible. It's not always possible, but if you can do it, it's certainly suggested to do so. One of the alternatives I would say that most people think of is arbitration. Arbitration is a creature of contract. When you have a contract with another company, you can have we call it an arbitration clause in whatever agreement you're talking about, and you can determine where the arbitration will sit, like what state, where it's located, even what country, what law applies. You can contractually agree to all of that beforehand. The other difference between arbitration and litigation, and why most companies you'll see, when you click to agree to terms and conditions to different websites and stuff, if you actually read through it, most of those things are going to contain arbitration clauses. Why a lot of companies pick arbitration over litigation is that arbitration is confidential. If you file suit in federal court, the existence or knowledge of the dispute is public. When Apple files suit against Samsung, it's headline news, everyone knows. If there's a dispute that is required to go through arbitration, it is confidential. It's not going to hit the headlines. No one's going to know about it. It's private. It's settled privately. So that tends to be, I think, the biggest reason why a lot of companies will pick arbitration. In my experience, arbitration is not necessarily less expensive. Sometimes it matches the expense of litigation. Sometimes it is even more expensive. So I wouldn't pick it if, you're that concerned about expense. But the privacy aspect of arbitration tends to be the selling point for most companies. Again, and it's listed on the slide, arbitration decisions tend to be binding and they are very hard to overturn or appeal. You're very limited in what you can do once a decision is rendered. Whereas if you go in district court, there are several rounds of appeals that you can have if you don't like the decision.
Mhm.
Another thing that people tend to use or can use is mediation. In my experience, mediation tends to correspond with litigation. You have parties that are already at the point of whether a suit may have been filed already. Mediation is where you have an independent party coming in and basically negotiating a resolution. So rather than going through the length and expense of a litigation, the parties decide that they want to resolve it, they don't want to litigate, and they need a third party to help them navigate that. The hook with mediation, especially in my experience, is you need the parties to actually agree to want to resolve the dispute. A lot of times when you have two parties that are already litigating, litigation is threatened, they're too far apart, there's not going to be any way for them to agree to a resolution. But if you have an instance where both parties, neither wants to actually litigate, mediation can be another alternative that can be very beneficial.
Yeah, I work for a very small nonprofit, and litigation would be catastrophic to our bottom line. And in the agreements that I negotiate with our partners, I like to start with negotiation between senior officials of the parties, and hopefully that resolves the issue because we don't really want to go further, in a dispute because of the cost. It's all about the money for us because we're so small.
Right.
And I've worked with very savvy outside counsel who have guided us in the best ways to resolve disputes without going to litigation. I know that perhaps in some instances that takes money out of their pocket, but they know their client and they know that we really can't afford it, and they help guide us. I wanted to just ask one additional question in the last minute or two that we have, just as an omnibus. Uh, what are some of the current hot topics in intellectual property which the attendees today should be made aware? I mean, what's what's big in the news and what could potentially impact their business? And I'll open that up to everyone if you have one that you've seen in your practice that you could tell us about. Neil, how about you? We'll start with you.
Yeah, I alluded to earlier, we're still a lot of debates about whether AI can be freely trained on other people's materials without their permission. And that's still being fought through the courts. Part of the interesting problem there is, as humans, we could go read a book and we haven't necessarily violated someone's copyright just by reading their book, especially if we lawfully acquired the book. And some argue, well, that's what the AI is doing as well. Now, others, so should it be any different? It's just reading the book. It's not necessarily reproducing the book. Now, on the other hand, there have been accusations that, well, the AI could reproduce the book or could end up creating a substitute for the book. So that's still being worked through the court system. I think we have a lot of interesting decisions that we'll be able to read in the coming year or two.
John, how about you?
Yeah, I guess in the patent field, although I'm a trademark attorney, our firm does a lot of IPRs at the patent office, and there's been with the recent change in administration, there's some indications that the number of IPRs going to be granted, is going to be significantly decreased. So that's good for patent owners and perhaps bad for defendants in patent litigation cases.
Gianna, how about you?
So in the business agreement strategic alliance space, along with Neil, I'm interested in watching how AI evolves, particularly for companies that are based on or use machine learning models. At what point is our models and machine learning, which we've had for a long time, is that considered AI? What are the requirements that are going to now be held? Just like we've come to alignment on like what are the requirements related to privacy, we're now in that world related to AI. What are the standard requirements? What are companies going to have to do, or certifications that they're going to have to meet? So that's what I'm watching.
Deanie, you have the last word today.
I think absolutely AI is definitely a topic that everybody is talking about in general. I think from more broadly, I think honestly trade secrets are having more of a moment. I think as more and more companies and employees understand what trade secrets are, what they can actually protect, more and more companies are getting more comfortable with enforcing that.
Excellent. And with that, we will be ending today's webinar. And I wanted to give a very loud shout out to our panelists today, Gianna Julian Arnold, Deanie Savasco, John O'Malley, and Neil Peretz. If anyone who has attended today has any questions for our panelists, you can submit them to info@financialpoise.com, and we will ensure that your questions are answered. And with that, the webinar is ended, and have a wonderful day, everyone.
Thank you.